Hello, good morning, everyone. And before I begin my presentation, let me take this opportunity to thank the organizers and especially thanks to Dr. Yuvraj Bhosle for inviting me to share my thoughts on pertinent topic of medical negligence. So today I will be taking you through the basics concepts of medical negligence. I'm sure that you're all aware about what is medical negligence since the conference is of forensic experts. So I'm sure you know what this is. But I will be focusing more on the conceptual part, and subsequently, I will be taking you through some of the landmark judgments of the Honorable Supreme Court in this regard, which has set the medical jurisprudence in motion in this country. My name is Advocate Amit Karkhanis, and I'm practicing medical legal law since last 25 years. I'm based out of Mumbai, and this is the area of expertise that I have been practicing since last so many years. So without wasting any time, let's begin. Definition of negligence is very clear. Everyday use the word negligence denotes mere carelessness. In legal parlance, negligence signifies failure to exercise a standard of care which a doer as a reasonable man should by law have exercised in given circumstances. So these are basic, definitions, general definitions of medical negligence. As far as legal definition is concerned, medical negligence is an act or omission by medical practitioner who deviates from the accepted standard of practice in the medical community and which causes injury to the patient. So there is an act of omission and there is an act of commission. So either you do something which you should not have done, or you don't do something which you ought to have done. So basically, these are the two angles, these are the two aspects of medical negligence, which every court in the country, as far as civil courts are concerned, will look at. Uh, and there has to be either of the two present if a doctor or a medical practitioner has to get convicted of medical negligence, or a civil court or a consumer court will have to hold them medically negligent, then either of the two has to remain present in the circumstances. What is negligence? Negligence is an omission to do something, like I mentioned, error of omission, which a reasonable man guided upon those considerations which ordinarily regulates the conduct of human affair would do, or do something which a prudent or reasonable man would not do. So the first point is about error of omission and commission. All medical professionals, doctors, nurses, and other healthcare providers are responsible for the health and safety of their patients and are expected to provide highest level of quality of care. So if you admit a patient under you, obviously you are expected to have that kind of skill and expertise. And once you accept a patient or register a patient under you, you are also expected to give that level of quality of care. Unfortunately, medical professionals and healthcare providers can fail in their responsibilities to their patients by not giving them proper care and attention, thus causing far-reaching complications like personal injury or even death. Over the years, the functioning of the hospitals have slowly changed from venue for treatment to a provider of treatment. So there is a problem of perception nowadays. We have big hospital, five-star hospitals with facilities which match that of a five-star hotel. So obviously, when you have those kind of facilities setups, the expectation of the patients goes up, and this is a problem of perception. And once this problem starts, that is when the negligent seeds are sown in the minds of the patient. So, right now, it's not just a venue for treatment, but a provider of treatment, and hence the hospitals, doctors, nursing homes are service providers, and hence they also fall under the definition of service providers and under the Consumer Protection Act 2019, and even in the earlier act they were included. So there were a lot of misnomers and miscommunications about the medical professionals with being dropped from the definition of service provider, but that is not the case. Till such time you take money for your services, you are always a service provider. And when a patient pays you for a service, he is always a service taker. So giver and taker relationship has to be there. There has to be monetary exchange of funds for this definition to come into play. So if you treat someone for free, then obviously there is no element of consumer relationship. There is no relationship of service provider and a service taker. So treatment which is given free or pro bono ideally does not fall under the domain of consumer protection. And but there are various angles to this. This is not the right time to go into it. But most of the hospitals which provide totally free service are out of the scope of medical negligence. Acts that shall comprise of medical negligence. These are some of the examples. Legal duty to exercise due care on the part of the medical professional. Failure to inform the patient the risk involved. Obviously, the consent element kicks in here. So when you take a consent, it is your duty to inform all the risk factors and probable alternative to the treatment that the patient is willing to undergo. Patient suffers a damage as a consequence of undisclosed risks by a medical professional. It's very important that your consent is very, very important. Samira Kohli's judgment is a landmark judgment in the field of consent. 2008 Supreme Court gave that judgment, and until today, that is a gold standard as far as consent is concerned. If the risk has been disclosed, the patient would have avoided the injury. So patient has a choice. The patient has an autonomy over choosing whether he or she wants to take the treatment or no. You cannot force a patient to undergo a treatment under you or in your hospital. So that choice the patient has to make himself or herself. Breach of the said duty would give rise to an actionable claim of negligence. Now, when I talk about actionable claim of negligence, I'm purely talking about civil negligence. These are the basic types of medical negligence: civil negligence, criminal negligence, contributory negligence. We will see this one by one. Civil negligence is a form of negligence in which a patient brings an action for damages in a civil court against the medical attendant or who owed him a duty of care if he has suffered injury due to the negligence or unskilled treatment of a doctor. So this is basically goes to the consumer court, civil courts, and this does not go to the criminal court. This is mainly for the money part, the damages the patients claim, normally the damages because of the loss they suffer. Uh, Criminal negligence is a gross or culpable neglect or failure to exercise reasonable care and precaution to guard against injury generally to an individual which it was imperative duty of the doctor to have adopted. So this is the criminal part which goes to the criminal court. Magistrates are the ones who try this case. But there is a police case also which can be filed, and there is a process given under the Jacob Matthews judgment which we will see later on. Under the criminal law, for a person to be prosecuted, proving of the presence of mens rea or a guilty mind is required. Mere carelessness or simple lack of care may constitute a civil liability, but not a criminal liability. However, in a criminal medical negligence, it need not be because of mens rea as intent. Sans mens res in above sense also would still constitute offense of medical negligence. The difference between civil negligence and criminal negligence is very important. The distinction between civil medical negligence and criminal medical negligence is very thin. In civil suit, it is sufficient to prove a neglect of a doctor, but in criminal case, it is necessary to prove beyond reasonable doubt. So, in a criminal case, like you all know, I did not emphasize there has to be an element of mens rea where the doctor has to be deliberately negligent. The prosecution has to prove to the court that it was deliberately negligent. The doctor was deliberately negligent. He did that act or a deed deliberately. Criminal negligence is when a doctor does an act which is in regard to an obvious risk of the safety of human life, whereas civil negligence is negligence where a doctor omits to take ordinary care. So the difference between civil and criminal is risk and ordinary care. Contributory negligence is normally a form of defense which we take in a civil court. That is when a patient does not do something which a doctor has told him to do. Contributory negligence is an unreasonable conduct or a negligence on the part of the patient himself or herself, which is the cause of the harm complained of, although the doctor was also negligent. As such, doctor's negligence is not the direct proximate cause of harm suffered by the patient. This is very important point that we need to keep in mind that contributory negligence, the ultimate damage to the patient or suffering should be linked to the patient himself or herself. The direct cause of that should not be linked to the doctor's action. So that is when the contributory negligence kicks in. We can successfully take that as a defense. In such case, doctor's negligence does not, in the eyes of the law, materially contribute to the damage, like I mentioned. So the action of the patient would be such that the cause or the suffering that is undergoing is because of his own actions. Now, let us quickly see what are the various judgments that the Supreme Court has passed over a period of time. Obviously, you all must be aware about this judgment of Jacob Matthews. Jacob Matthews versus State of Punjab is one of the landmark cases which defined the scope of the medical negligence in this country. This is a case where the Honorable Supreme Court laid down those guidelines where, you know, uh, where before filing of an FIR, it is imperative that the police should send the papers to the government hospital or a civil hospital in whose jurisdiction the police station is there, and take an expert opinion from the medical board. So the medical board has to opine whether the treatment done by the patient, the treatment given to the patient by the medical practitioner or a doctor was right or wrong. And unless the medical board certifies that or medical board says that it is not possible for the doctors to register an FIR. So it says that a private complaint may not be entertained unless the complaint provides prima facie evidence before the court in the form of credible opinion given by another competent doctor to support the charges of the rashness or negligence on the part of the doctors. This is definitely one of the keystone judgments in the history of Indian law as far as medical negligence is concerned. After this law, there has been a lot of relief to the medical practitioners. Obviously, there is a lot of burden on the government machinery where a lot of police stations sends the report, papers to them for their medical opinion. But nevertheless, there is a check and balance here, which has been created by the Supreme Court. Supreme Court laid down these guidelines long time back, and till today, as we speak, even now, the police stations have to send the papers first to the nearest government hospital. In case of Mumbai, they have to send this to JJ, and when the JJ gives the JJ committee or the medical board set up by the JJ hospital gives its opinion, then only the police can take any further action. So this is a very major safeguard which the Honorable Supreme Court has given as far as medical negligence is concerned in the criminal side. And as far as civil courts are concerned, there is no compulsion on the courts to take the medical opinion from any government hospital. It is the court's discretion. Uh, Earlier, in Jacob Matthew, in Dr. Martin D'Souza versus Ashfaq Khan's case, the Honorable Supreme Court had said that even a civil case cannot go forward without an expert opinion, but that judgment has been held to be per incurium by a subsequent judgment by the Honorable Supreme Court in Nikhil Super Specialities case, where the court has clearly given instructions and guidelines that it is the forum or the court which will decide whether they need the consumer, whether they need the medical opinion or no. Okay, so it is for the civil courts, it is not compulsory anymore. But as far as criminal cases are concerned, it is extremely important for them extremely important for the police to obtain the necessary permissions before necessary opinion from the medical board before they register an FIR. Till such opinion comes, the police cannot even register an FIR. That is the law of the land. Now, this is another judgment where the commission observed that this is an NCTRC judgment. The commission observed that the hospital who employed all of them, whatever the rules were, has to own up to the conduct of its employee. So this was also repeated in a very famous judgment of Kunal Saha versus Amri Hospital in the Honorable Supreme Court, where the hospital is vicariously liable for all the actions of its employees. So this is just the reiteration later on by the Supreme Court of the fact that if you're owner of a hospital, you are vicariously liable for everything under the sun that happens under you. For your full-time consultants, part-time consultants, nurses, registered nurses, unregistered nurses, qualified, unqualified, security, everything you are responsible. Any bill, including consulting doctors' consultation fees, are raised by the hospital on the patient and it deducts 20% commission while remitting fees to the consultant. Whatever be the outcome of the case, hospital cannot disown their responsibility on the specific superficial grounds. So this is very clearly a judgment which deals with vicarious liability, and now that vicarious liability has been upheld by the Honorable Supreme Court in Kunal Saha's case. That's a very big case. I think it was 120 pages judgment. Uh, this judgment further goes to say that the hospital authorities are not only responsible for their nursing and other staff, etc., but also for their anesthetists, surgeons who practice independently but admit and operate cases. It does not matter whether they are permanent or temporary resident or visiting consultation, full or part-time. So this is very clear, same plain, simple English, and I don't think that we need to emphasize more on this. This is the latest judgment, Maharaja Agrasen Hospital versus Rishabh Sharma. This is a hospital which is there in Gurgaon, I assume. Complainant, this is a case where the Honorable Supreme Court held that upheld the well-established principle of tort that the hospital is vicariously liable for acts of its negligence committed by doctors engaged, empaneled to provide medical care on the ground that it is common that when a patient goes to the hospital, she goes there on the account of the reputation of the hospital. Now, this line is very important that the patient goes with the name and reputation of the hospital, and hence hospitals are vicariously liable with the hope that due care and proper care will be taken by the hospital authorities. If the hospital fails to discharge its duties through the doctor, through its doctors being employed on job basis or employed on contract basis, it is a hospital which has to justify the act of the commission or omission on behalf of the doctors. So whatever the consultant does, it's immaterial. It is a hospital equally responsible. Consultant is also obviously responsible, but hospital is more responsible vicariously, and this principle has been upheld in every medical negligence case which is coming out of consumer courts. There be rest assured that the judgments which are being passed, hospitals are made necessary parties, and the judgment, the courts are very clear that the liability is equally on the consultant and the hospital. So Honorable Apex Court granted 76 lakhs as a compensation in this case. This was a judgment given by Justice Lalit, who was a former Chief Justice of India. Now, this is a judgment which I was referring, which made it you know optional uh, for the consumer courts to send the matter to the medical board. The Supreme Court held that before forming opinion as to whether the expert evidence is necessary in the consumer forum under the Act, the court must come to the conclusion that the case is complicated enough to require an opinion of an expert. So this is very important. So this very clearly gives the power to the consumer forums to decide if it is complicated case. Only then they are bound to take an expert opinion. Otherwise, they are not required to take an expert opinion. If the facts of the case before the consumer forum are clear and they can make out that the doctor was negligent or not negligent, then there is no way or there is no need for the matter to get dragged on for years because of the expert opinion. So this judgment is very important. As of now, this judgment stands because the earlier judgment of Martin D'Souza has been held for incurium by this bench, and there is no reference made to the larger bench, basically. So what for incurium means is that the judgment which was earlier passed was wrong in the eyes of the law. So this bench corrected that judgment, so to say, and since both the judgments were given by the two judges of the Honorable Supreme Court, there is absolutely no way that now, unless there is a larger bench, this judgment can be overruled. So that's why this Nikhil Stoper specialty judgment is now in place, and this is being accepted by all the consumer forums across the country. So these were some of the judgments that I thought were very important as far as medical practice is concerned. There are obviously there are a lot of judgments which come every day, day in and day out. What matters is the key elements and the key judgments which define the scope of the um, consumer of the medical jurisprudence in this country. Another judgment which I would like to mention here orally right now is that of Samira Kohli's judgment. Samira Kohli's judgment deals with the topic of consent, how the consent has to be there, what are the contents of the consent, how much you need to tell the patient, and it very clearly gives the choice to the patient to make a choice, whether it gives an option to the patient to make a choice whether to take the treatment or not take the treatment. So from that point of view, these are three, four judgments which are very well defined, which has set the tone for the medical jurisprudence in this country. And If you all are forensic experts, then I'm sure you have read the law also along with your training and your day-to-day dealings with forensics. And I have seen some of the best medical legal consultants coming from the field of forensics. And due to the paucity of time, we could not take, I could not take the other judgments. But if given an opportunity, I'll be happy to share some more judgments in the future. For the time being, thank you very much. If you have any questions, please drop them in the chat box. I'll be very happy to answer. Thank you.